In today's video, we discuss legal issues related to health coaching and unlicensed medical practice. Hi, I'm Michael H. Cohen, founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal issues so you can launch or continue to scale your health and wellness product or service. Now, consider Joe a health coach who has many certifications as well as celebrity clients. 3 years ago, Joe left his chiropractic practice and built a virtual coaching practice in which he teaches lifestyle, nutrition, behavioral modification, and a bunch of wellness approaches. Good for Joe. I believe in it. When Joe articulates his philosophy, it's spellbinding. Truly, Joe knows his stuff. He says that treating with drugs and surgery as your go-to is damaging, not for every situation. He says a lot of people are in some kind of health crisis. We've got a medical system that focuses on treating diseases and people don't know how to stay healthy. He says there's a lot more to health than cracking backs or seeing people in the emergency room. He talks a lot about detox and good food and environment and maximizing your immune system, providing the building blocks to good health. Now, one thing Joe does do is he reads your labs. Because he's trained as a chiropractor, he's got a clinical mind, and he's got training in functional medicine. Joe's watched our videos or read our healthcare law blog posts. He comes to us asking for just a simple consent. Well, you can get consents off the web, but he'd rather hear it from an expert. Okay, good for Joe. Glad to have him. Now, we do have some hard news to break to Joe from the perspective of lawyers. We believe in him. We believe in his approach to health and wellness. We use similar approaches ourselves. We walk our health talk. The problem is that healthcare law divides health and wellness providers into two basic types, licensed and unlicensed. You're either functioning as a licensed practitioner within your scope of practice. For example, you're a licensed MD or licensed chiropractor, acupuncturist, psychologist, dentist, registered dietitian, or some other licensed category, or not. If you're licensed but not an MD and you're operating outside your scope of practice, that can be considered the practice of medicine. So, for example, if you're a licensed chiropractor, you say you practice functional medicine, essentially you're broadcasting that you practice medicine. Now, this is risky or less risky depending on the state you're in, but the basic lay of the land is the same. Medicine is medicine. If you say functional medicine, you can't blur the second word or cough over it or pretend you didn't say it. So we talk on our blog and in other videos about state regulation of nutrition and dietetics. This is yet another area to watch for, and unlicensed practice of psychology. But in a nutshell, a main challenge Joe's going to have, besides promoting a functional medicine approach as a chiropractor, is that he wants to review labs. Typically, that would be considered unlicensed practice of medicine, especially if he says all he's doing is coaching. Now, we're not saying you can't be a health coach. That's a double negative. There are national organizations dedicated to promoting the idea of health coaching and promoting the idea that there is a range of activities one can carve out below the radar of medicine. But there's a slippery slope, a blurred line between those activities that require a license and those that don't. And you don't eviscerate this line simply by hiring a lawyer to draft a simple, quote-unquote, just disclaimer. That'd be like going in guns blazing to rob a bank, all the while carrying a large sign that says, disclaimer, this is not a bank robbery, fine print. But please keep your head down while we dip in the cash register because the guns are loaded. Some things you can disclaim, some things you can't. That is a bank robbery. So the art is knowing the difference. And that's why you owe it to yourself to get professional advice. It's like the old story of the engineer who charged $10,000 to get the train moving again. All he does comes with a hammer and find one nail that's out of place. And he hammers it in. The train moves. When he's asked how he could charge $10,000 for that activity, he says, it's $1 for tapping and $9,999 for knowing where to tap. Well, thank you, Brian Tracy, for that story. And maybe we thank the people who gave you the story. And thank you for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.